Good morning, my respected audience and advocate on record aspirants. My today's topic is very important. It is topic relating to specially petition criminal. So be settled. I am going to discuss with you this important topic. Friends, when the client comes to you, your first task is to see the papers and take note of if there is any limitation dispute. So friends, firstly, how to calculate limitation, I am going to discuss. The petition for special leave to appeal not involving sentence of death would be lowered within 90 days, and in case involving sentence of death within 60 days from the date of judgment or order sought to be appealed from. However, in case leave to appeal to the Supreme Court was refused by the High Court, such a petition for special leave to appeal would be lowered within 60 days from the date of order of refusal. Friends, the above said limitation period has been to be calculated by taking into reliefs provided under sections 4, 5, 12, and 14 of the Limitation Act. Sorry for disturbance. Limitation 1963. The period during making of application for grant of certificate and rejection by the single judge of the High Court shall be excluded. The order refusing certificate under Article 134A of the Constitution is certificate of the nature referred to in Article 132 and Article 133 of the Constitution, but it should be wholly on merit. If the order rejecting an application for point of limitation is due to other grounds, such as the applicant was not maintainable, then it will not be excluded. In case the period of limitation claimed from the date of refusal of the certificate under Article 134A of the Constitution is certificate of the nature referred to in Article 132 or 133 of the Constitution, it shall not be necessary to file an order refusing the certificate. The petition for special leave shall be accompanied by an affidavit enclosing that date of judgment sought to be appealed from, date on which application for certificate of fitness to the appeal to the court was made to the High Court, the date of order refusing the certificate, the ground or grounds on which certificate was refused, and particularly whether the application for certificate was dismissed being out of time. Now, friends, as far as format is concerned, as per Article 136 of the Constitution, it should be filed in Form 28 of the fourth schedule of the Supreme Court Rules 2013 as applicable to special leave petition civil under Rule 3 subclause 1 of the Order 21 of the Supreme Court Rules 2013 with necessary modification and adaptations prescribed in Order 22 of the Civil Service Rules 2013. SLP must be confined only to the pleading before the court tribunal whose order is challenged and other documents relied upon in these proceedings. No additional facts, documents, or ground shall be stated or relied upon without the express provision of the Supreme Court, which is obtained on an application made for this purpose. Friends, there are statements, disclosures, and declarations in the SLP, which have to also be kept in mind. Firstly, the registry will not maintain entertain any petition unless it contains statement as to whether the petition has been filed for special leave to appeal against the judgment or order earlier, and if so, with what results, duly supported by an affidavit of the petitioner or his perocar. The court shall, if it finds that the petitioner has not disclosed the fact of filing a similar petition earlier, and its dismissal by the Supreme Court, will dismiss the second appeal. And if it is pending or if special leave already has been granted, that it will revoke the same. Friends, we have to accomplish with the petition a certified copy of the judgment or order appealed from and a affidavit in support of the statements of facts contained in the petition. Friends, no annexure to the petition shall be accepted by the registry unless such annexures are certified copy of the documents which have formed part of the record of the case in the court sought to be appealed from. However, uncertified copies of the documents may be accepted if such copies are affirmed to be true copies upon affidavit. So be careful while attaching annexures. And in case of criminal petitions, the most important part is relating to surrender or exemption from surrender. Friends, where the petitioner has been sentenced to term of imprisonment, the petition of appeal shall state whether the petitioner has surrendered, and if he has surrendered, then the petition shall, by a proof of such surrender, he shall file a certified copy of the order of the court in which he has surrendered or certificate of the competent officer of the jail in which he is undergoing sentence. A mere attestation of signature on the Vakalatnama from jail authority shall not be considered as a sufficient proof of surrender. Where the petitioner has not surrendered to the sentence, the petition of appeal shall not be accepted by the registry unless it is accompanied by an application for seeking exemption from surrendering. Where the petition for it is accompanied by an application for exemption from surrendering, the application alone will be posted for hearing and orders before the court in the first instance. Friends, there are also rights and duties provided to the respondent. The respondent is at liberty to file his objection within 30 days from the date of receipt of the notice or not later than 2 weeks before the date appointed for hearing, whichever is earlier. Now, friends, if the accused in jail, then there is also a procedure for jail petitions. If the petitioner is in jail and is not represented by an advocate on record, he may present his petition for special leave to appeal together with a certified copies of the judgment and any written argument which he may desire to advance to the officer in charge of the jail. When the officer in charge of the jail receives that, he shall forward the same to the registrar of the Supreme Court, and further the registrar of the Supreme Court shall, wherever necessary, call from the proper officer of the court or tribunal appealed from the relevant documents for determination of the petition for special leave to appeal. As soon as all necessary documents are available, the registrar shall direct the engagement of an advocate from the panel of Supreme Court Legal Service Committee or assign panel advocate at the cost of state. Therefore, place the petition and complete documents for hearing before the court. The fees of the advocates so engaged shall be such as may time to time be fixed by the Honorable Chief Justice of India and shall be paid within 3 months from the date of his presenting claim for the fees supported by a certificate issued by the concerned registrar. If the fees are not paid within 3 months from the date of presentation of claim supported by the said certificate, such fees shall be recovered from the state or the union territory as the case may be concerned by enforcement of certificate as an order as to costs under the Supreme Court Decree and Order Enforcement Order 1954. Friends, there are two stages of special leave petition, that is, conversion of special leave petition into appeal. Friends, jurisdiction conferred on the Supreme Court under Article 136 of the Constitution had two stages as per Order 22, Rule 8 of the Supreme Court rules. First stage is up to the disposal of prayer for special leave to file an appeal, and second stage commences if and when the leave to appeal is granted and special leave to appeal is converted into an appeal. On the granting of the special leave, the petition for special leave shall be treated as petition of appeal and shall be registered and numbered as such. Friends, there are also cases that while listening to the appeal, it comes to the notice that of the Honorable Court that this appeal is capable of being disposed of in 1 or 2 hours, then the bench of the Supreme Court, while granting special leave in all matters in which it is of the opinion that matter is capable of being disposed of within a short time, that is within an hour or two, it will indicate accordingly. The office shall maintain a separate register of such matters to enable the Chief Justice to constitute a bench for the disposal of such matters. Friends, after these things, there is requirement of intimation to the court appealed from about granting of leave. Upon an order being made granting special leave to appeal, the registrar shall transmit the court appealed from a certified copy of the order together with certified copy of the petition for special leave and the affidavit, if any, filed in support thereof. Friends, there is also a need to service of respondents and requirement of record of the case. On receipt of the said order, the court appealed from shall give notice of the order to the respondent and require the party to take all necessary steps to have the record of the case transmitted to the court in accordance with the directions contained in the order granting special leave. The registrar of the court appealed from shall certify to the registrar of the Supreme Court that the respondent has received notice of order of the court granting special leave to appeal. Friends, there is also a case when special leave to appeal from orders of the Under Armed Forces Terminal Act 2007 are laid. So when the type of SRPs come before the Supreme Court, the provisions contained in Order 21 relating to special leave petition shall apply to the applications for leave to appeal to the Supreme Court under second part of the Section 31, Subclause 2 of the Armed Forces Terminal Act 2007 with such modifications and adaptation as may be necessary. So, friends, this is all about SLP criminal. God bless you all. See you again.